Good afternoon, everyone. Thank you so much for being here. My name is Kelly Beard, Content Specialist for Maryland Realtors, and I want to welcome you all to our Legal Hot Topics webinar. Today, we have with us Director of Legal Affairs, Kathleen D'Ortez, along with our Associate Counsel, Taylor Kitzmiller and Diamond Smith. Together, they will dive into legal questions they've been receiving frequently. This webinar will be recorded and sent out to all attendees after the conclusion of the webinar. We do encourage your questions, and we look forward to answering them as we go. Please post all of your questions in the Q&A box at the bottom of your Zoom screen. And with that, I will turn it over to Kathleen. Kathleen, take it away.
Great. Thanks, Kelly. And thanks, everyone, for joining us. We are going to go through an hour and hopefully give you some good content. We do have a slide deck we're going to share.
One second.
Okay. We will pull that up and we'll start out with our, oops, we're seeing too much there. There we go. Okay. We'll go ahead and start with our agenda. I'll give you an idea of what we're going to talk about today. We're going to start with seller impersonation fraud. This is something that some of you may have experienced already, or some of you may have read about it. It's kind of a hot topic across the country. We're going to start out with that, give you some explanation of what it is and maybe some tips for you all, to protect yourselves, and information you can share with your clients and hopefully help them protect their interest in the property as well. We're going to go also next into fair housing, which is a perpetual hot topic. We're going to start out with reasonable accommodations and modifications, and then assistance animals. And Taylor's going to give us that information on assistance animals and focus a little bit on how to process a request for an assistance animal. So if you're working with landlords or tenants doing any property management, that's really important information. And then he's going to pass the baton to Diamond, who's going to talk about source of income. I think all of you guys know that Maryland added source of income as a protected class across the state in October of 2020. We still get a lot of questions on that, and Diamond's got some good information she can share with you on that as well. And then we are going to talk about the escrow agreement. Taylor, I think most of you guys know Taylor is a staff executive for our statewide forums committee. So he's going to give you a little information on the form, the escrow agreement itself. And then there is a recent change in Maryland law regarding EMDs and return of the EMDs. So Taylor's going to go into a lot of detail, painful detail. No, he'll go into sufficient detail on that. So you guys will have a better understanding of that when we finish up. And then we are going to conclude our piece with advertising. There's been some changes in the past year and a half with the Real Estate Commission's advertising requirements, and also some enforcement actions. So we're going to cover that to make sure you guys understand those changes as well. And then hopefully we'll have a little bit of time at the end for a Q&A. So I think, as Kelly had said, if you have any questions, you can type them in the Q&A, and each of us will keep an eye on that, and we'll answer those. If we can answer them online, we'll do that. If there's something that's not clear, we'll go back to it. We'll read it out loud. And if there's time at the end, we'll cover some of the additional ones at the end of the session. All right, so I think we are good. We can go ahead and get started. Seller impersonation fraud. Like I said, some of you may have experienced this already. I've seen an uptick on legal hotline calls. I think in the past month, I've had maybe 4 questions about this specifically. What's happening is this is a scam being perpetuated across the country. Typically, what it would be a vacant land, often in rural areas. A lot of the scams are often in cities or areas like that. This is sort of the flip side of that. This is happening more often out in the counties and in rural areas. And the gist of it is someone is impersonating the seller. A scam artist is impersonating the seller. And the seller is desperate to sell this property. They want to sell it very quickly. So they're going to reach out to who? They're going to reach out to a listing agent, right? See if you can help them sell this property. And what it is, the person who's the scam artist, they do not own the property. Obviously, they're scamming. They seem to, somehow they must have access to the land records and be able to access land records because they're identifying property that is generally rural. Generally, there's no mortgage or deed of trust on the property. There usually, no encumbrances on it. So that's kind of their target property. And they will contact a listing agent and say, I'm the owner of this property. I'd like to sell the property. And they typically want a fast sale, within a relatively short time frame, and typically they're interested in a cash purchase. And again, if you think about it, anyone who's perpetuating a scam, that makes perfect sense. Diamond will talk about source of income, where we can't have just cash purchasers here in Maryland, so that's a red flag number one. But some of the things for you as a listing agent, if there are red flags or things you should be paying attention to, it's kind of I think if you think the person might be a scam artist, these things again sort of do make sense. The person will generally not meet with you in person. All of your contact with this person will be electronic, by text or by email. You won't see them in person. They will generally be hesitant about showing ID. Some of those things sound like red flags and sound very obvious. I spoke with someone on the legal hotline just a week or so ago who had dealt with one of these sellers just for a day or 24 hours. And she said she was a little bit surprised because the person seemed to be familiar with the area. You would think typically a scam artist would not be familiar with the area, and you might be able to kind of pick up on it. And she said this person really was at least somewhat familiar with the area and answered questions. So there were no obvious red flags. But at some point, you're going to have to, you're going to have to identify your seller, figure out who the seller is. And I think there's, I guess that's sort of the seller side right here, what's happening here. Another piece of it, of course, fraudsters and scam artists, generally, they don't operate alone. Typically, there's going to be maybe a title company that's also part of the scam or involved with it, or a notary who may be involved. Again, that's kind of a red flag for you as a listing agent. If the seller's going to sign things or try to have things that are notarized outside of the area, notarized remotely, that might be a heads up for you as a listing agent. It should really be a big red flag for the title company. Most title companies will not allow that. The title company is going to want, the people to appear in person, show a government ID, and use a notary that is approved by the title company. So there's a couple red flags there. You want to maybe go to the next slide, Taylor? Yeah, so this is basically how to prevent this. This slide that we're showing, I should have mentioned this. This is a screenshot from an infographic that was prepared by the United States Secret Service, believe it or not. That kind of tells you how widespread this fraud is. And they were made aware of it throughout the country, so they gave some guidance on this. So a lot of times, if the listing agent doesn't pick up on it, if there is a buyer who's going to put an offer in on this property, sometimes if the title company is part of the scam, this may not be picked up until after the deed is recorded. And that's really what we want to all work together to try and prevent that from happening, make sure the deed is not recorded, because then it's going to be much more difficult to undo that. And again, if you guys have read headlines on this, you may see this is happening. It's happening a lot in Florida. There's a lot of elderly people in Florida and people maybe who own their property outright. And these people are being taken advantage of and sometimes, losing title to their property or having to pay attorney's fees and go to court to try and keep their property or get their property back. So it is a big deal. So basically, here's our tips here, how to prevent it. It says independently search for the identity and a recent picture of the property seller. This, I would say, it depends on how comfortable you are, with the land records, tax records. If you could pull up the identity of the actual owner, one of the best pieces of information, I think, if the tax records show the address of the person, contact the actual owner. Try and contact them through a different source. Go online and find another way to contact them rather than just responding to whoever initiated the contact with you in case they're a scam artist, right? You would want to try and meet them at least virtually if they won't meet with you in person. Want to maybe check their ID, make sure that the ID they're presenting matches the person who owns the property. And again, this other bullet point up there, if the seller is honestly a little bit desperate to purchase the property, if they're going to accept an offer that's below market in order to get cash or close so quickly, that should be a little bit of a red flag. I think with our market today, there's still a shortage of inventory. That probably is a red flag right there. A quick offer below market. That's generally that's an unusual response for a seller to take, or a position for the seller to take. Never allow the seller to arrange their own notary closing. Again, that's more of a title issue, title company issue, but just pay attention to that. If your seller is insisting that they have a notary, their friend's a notary, their cousin's a notary, they don't need to use a notary here. Just reach out to a title company and have check with your title company, because typically the title company will not allow that to happen. A legitimate title company doing a little legitimate settlement, they need to make sure that the seller is actually the seller. If there are, two owners, these are the right two people. The title company is going to want one of their notaries to go through the process, make sure everything is done properly. A legitimate title company generally would not allow someone to waltz in with something being notarized by a random person that they're not familiar with. So all of those are red flags. Reach out to your friendly title company if you see this. One other suggestion for the owner of the property. We did have a call, also it wasn't the legal hotline, just a member of the public called in, and this one guy that I spoke with, this had happened to them 3 times. I think his parents had passed away and he was the personal representative. He had taken title to the property. It was some land in a rural area, no mortgage, no deed of trust, no liens on the property, and his property had been listed for sale 3 times, I believe by 3 different scam artists. So one suggestion for your sellers would be if they could set up a Google alert. You can Google it. You can Google how to set up a Google alert. No surprise there. But what they can do, they could type in the address, the property address, and they would receive an alert whenever that goes online. So if someone lists that for sale or markets that online, that property address would trigger that alert, and the owner of the owner of the property would receive an alert from Google. Hey, and you can see what's being listed or where it's being listed, where the mention of the property is being made, and that would be sort of a little safety net for the actual owner of the property. Again, just thinking about this as a nationwide issue, there are some other states that are starting to take some steps to try and to prevent this really. And our advocacy team here at Maryland Realtors, they are aware of this issue and have been discussing that, and I think checking out some legislation that's been proposed in other areas. So just pay attention to that. I think we may have an update, maybe next legislative session, to see if there's something that could be done legislatively to try and rein this in. And I know several of our members actually have been super helpful and are working with some of their elected officials to try and see if there's something that can be done, at least here in Maryland, to help prevent this and make sure this doesn't happen to us and to our clients. So that's the situation. That's what's happening. And just heads up, we'll be giving an update as things progress. And I think that's it for that. Taylor, you want to go ahead? I'm going to pass the baton to you, I think.
All right. Sounds good. Thanks, Kathleen. All right, so I will be discussing some fair housing hot topics. First, we will be discussing persons with disabilities, and specifically when a person with a disability requests a reasonable accommodation or modification. So first, a reasonable accommodation would be an adjustment to a business's rules, policies, practices, services. So for an example, you could have a condo where the condo assigns parking spots to their unit owners. That would be an example of a business rule. And depending upon what the request is, let's say you have somebody with a mobility impairment, that's their disability, and their parking spot is assigned 50 yards away from their unit, and they make the request for a reasonable accommodation to change that parking spot to be assigned directly in front of their unit. So that would be an example of a reasonable accommodation. Now, a reasonable modification involves a change to the physical structure of the premises. So we'll continue on with that. Unit owner who has a mobility impairment, they could request possibly to have a ramp installed to give them access to their unit. That's a great example of what a reasonable modification would be. So it's going to be unlawful for any person to refuse to make a reasonable accommodation or modification when that change is necessary to afford that person the ability to have an equal opportunity to use and enjoy their dwelling. And that third bullet there states there must be an identifiable relationship between the requested accommodation and the person's actual disability. So in other words, if somebody is deaf and they request to have a ramp installed in their property, those two really there's not an identifiable relationship there. that's needed in order to make that reasonable modification. So who does reasonable accommodations and modifications apply to? It's going to apply to property owners, housing managers, homeowners, and condo associations. So basically almost everybody. And a request for a reasonable accommodation or modification can be denied if it's going to impose an undue financial and administrative burden on whoever's providing that housing, or would fundamentally alter the nature of that provider's operations. So an example there could be, let's say that person with a mobility impairment requests that an elevator be installed in their unit. Well, that's obviously a major change to the physical structure of the property. It's going to cost a lot of money. And in that scenario, it could be likely that that request would be deemed unreasonable, and that property owner might not have to actually make that change. Okay, so getting away from disability-related requests, we're going to focus on how to properly process a request for an assistance animal. So this guidance that we're going to go through in these next couple slides comes directly from HUD and kind of walks you through exactly when you receive. The example we can use is a landlord. A landlord receiving a request from a tenant to have an assistance animal on the property. So these next couple slides, we're going to take it from the very beginning when that landlord receives the request to actually processing and determining whether or not they have to allow that assistance animal onto the property. So first, number one, what is exactly a request? Well, there's no requirements regarding what form or timing that request has to be made. So in other words, a tenant doesn't have to make the request for the assistance animal before they move in. They could move into the property and then later make that request. That's perfectly allowed. Also, the form the request comes in. There's no standardized form. That tenant could email the landlord, text the landlord, just make it clear that they are requesting to have an assistance animal join them on the property. HUD's guidance states that a landlord should try to respond to a request within 10 days after receiving supporting documentation. And landlords have the option to create and provide their own assistance animal request forms, but there's no requirement for that tenant to actually use the form that's provided. So at the end of the day, if the tenant wants to send an email and not use the landlord's form, it's up to them. They have every right to do so. Okay, so let's say you received the request. Now moving on to number two, does the tenant have a disability? So as I'm sure you all are very familiar, disabilities are a mental or physical impairment that's going to substantially limit one or more major life activities of a person. And the range of disabilities is quite wide. Obviously, the ones that are pretty common, a mobility disability, somebody needs maybe a wheelchair to move around, maybe somebody is deaf, but disabilities can range to apply to anxiety, drug addiction, alcoholism. So it's a wide range of what actually can be a disability. So long as it limits one or more major life activities, it's probably going to be considered a disability. So to qualify for a disability accommodation, that person must either actually have a disability, be perceived as having such a disability, even if that perception is wrong, such as where a landlord rejects an applicant based on a mistaken belief that that applicant has HIV, which was an old case, or have a record of such impairment, which an example there would be a recovered drug addict. That would still be possibly considered a disability for a recovered drug addict. All right, number three, does the animal qualify as an assistance animal? So assistance animals are broken down into two categories. First, you have a service animal. A service animal is a dog that goes through specific training to do work or perform a task that's going to benefit or help the person with their disability. A note here, if the need for a service animal is not readily apparent, in other words, if it's not observable, like somebody who's using a seeing eye dog if it's very clear that this person has issues seeing, and that, you know, that is a seeing eye dog for that person, you could not dig into asking questions about that disability any further. But if it's something that you can't see, so let's say for an example, anxiety, the landlord can ask whether the animal is required because of that disability and what work that animal has been specifically trained to perform. So that's service animals. And the second category is a support animal. Support animals are very wide. So any species of animal that serves the tenant's disability-related need, that animal does not have to go through specific training like a service animal does. So this is where you hear those stories about my pet parakeet helps me with my anxiety, and those types of animals that aren't typically are a little bit more unique than something like a service animal, which is a dog. Okay, so now number 4 here, did the requestor, so the let's say the tenant in our example, provide appropriate documentation to support their request for this assistance animal? So the landlord can only request verification of a disability, again, when that disability is not observable. That verification can come in many forms. So we have a list here: a notice from a government agency, a receipt of disability benefits, eligibility for housing assistance, information confirming disability from a healthcare provider. So basically proof that, yes, this person does have a disability. Now, landlords cannot ask about the details of the disability, require a tenant to undergo a medical examination, or require a medical professional to use a specific form that the landlord wants them to use, provide a notarized document, or make statements under penalty of perjury. So, but just kind of a side note here, there are examples, and we have seen them we've been told about them on a legal hotline and through other avenues, where there are some websites where people can go on and it says, hey, if you fill out this survey, at the end of the survey, we will provide you with a certificate that your service animal or your animal is an assistance animal, and they help you with their disability, and that's gonna cover you. That's gonna be a proper documentation to support your request. And it depends upon a couple things, but you have to have some personal connection or some personal connection with a healthcare provider who knows you and can say, yes, I know Jack's pet cat, helps him with his disability. What is not going to be a proper documentation is that site that I'm talking about, where Jack goes on the site, fills out a survey, and it says, hey, here's your certificate for your assistance animal. HUD's guidance is that that type of documentation is not enough. It's not proper documentation that's going to support that request.
Hey, Taylor, there's a question. What about service animal from agent side receiving the application? Where we don't meet in person to see?
I'm not sure I understand the question.
Sherry, can you rephrase the question?
Oh, is that like a listing agent? Say the listing agent is not showing the property, the tenant's agent is showing the property. I think it's a question about like whether the disability is obvious or visible. It's possible that the landlord may not actually see the applicant. Excuse me, the listing agent may not actually see the applicant. If the tenant has their own agent and that agent is showing them the property. I think that's a little trickier. I think I guess I would probably, if I were the listing agent, I probably would pick up the phone and call the tenant's agent and just speak with them. And if they're asking for an assistance animal, maybe just ask a little bit more information about that. I think if you don't know what their disability is, I think you would be permitted to ask for documentation to show that this person has a disability and a disability related need for the animal. I think that would be okay. If you have seen the person, if you've done, I don't know, you could do I don't know. If you haven't seen the person, I think you would be entitled to ask for documentation. I don't think you have to just say, yes, you can have your animal if you haven't at least, passed that sort of a little threshold there to at least establish that there is a disability and a disability related need for the animal. If you see someone, if you happen to be there when they're showing the property and you see somebody in a wheelchair or someone who's blind, I think that would be where you would not request documentation. But if you haven't seen the person, then I don't think you could say that the disability is obvious if you haven't seen the person. Taylor, do you have any other thoughts on that?
Yeah, I was just confused by the question originally, but now I totally agree with what your guidance there.
I think that was with respect to it being obvious, I think is what she was getting at.
Okay. Moving forward, is the requested animal accommodation actually reasonable? So it's going to be reasonable if, and there's 4 criteria, if it doesn't cause the landlord to incur undue financial or administrative burden, doesn't cause a basic or fundamental change in the nature of the housing program that landlord is offering or the housing provider is offering, will not cause harm or damage to others, and is technologically impossible. So the reason why that third bullet is bolded there is because that's typically where a request would be deemed unreasonable. So if somebody, if I live in an apartment complex and I request to have my tiger, my emotional support tiger, live with me, that's going to be probably considered unreasonable because it's going to pose a threat to the other unit owners in my apartment complex. Now, there's just a side note here that I want to add in that kind of came up on the hotline the other day. A lot of people, obviously, assistance animals do have some protections, but that doesn't mean that an assistance animal, if they are taking away from others' use and enjoyment of their property, it doesn't mean that assistance animal could be asked to be removed, or that tenant could be asked to vacate the, let's say, apartment complex. There was an example of a case down in Florida where there was 2 service animals, service dogs. They moved into this apartment complex. They were well behaved for multiple years, and then for whatever reason, they developed a bad barking habit. So they barked throughout the night. They kept up the surrounding unit owners, who eventually complained, and the apartment complex advised that unit owner who had the service dogs that they could either vacate the unit or remove the service dogs. Went to court, of course, the parties fought over it, and the court sided with the apartment complex because just like that unit owner who has the service dogs, the surrounding unit owners have the same right to use and enjoy their property as well. And if the service dogs are causing them to lose that right to their enjoyment, then they could be asked to be removed from the property. And finally here, number 6, are there alternatives to accommodation requests that are unreasonable? So if the landlord goes through this whole process, determines that accommodation request is unreasonable, they must determine whether there's an alternative accommodation that may be effective to meet that tenant's disability related needs. Okay, here's a quick question here. Can you charge a pet deposit to someone who uses an assistance or service animal or an emotional support animal? And since we're typing things in the chat, I'll answer it for everybody. The answer is no. And the reason why it's no is because an assistance animal is not considered a pet. So if your tenant has an assistance animal, just know that landlord cannot be charging any extra money just to have that animal on the property. Now, it doesn't mean that, if that animal digs up the carpet, destroys the paint, whatever, that landlord has the right to use the security deposit and possibly claim damages in excess of that security deposit, just as they would for a normal pet compared to that assistance animal. All right, I'm going to hand it over to Diamond now, who's going to discuss some source of income issues.
So with source of income discrimination, so with this, I don't necessarily receive a lot of questions on the hotline. However, we do receive questions during class instruction for fair housing. So I want to touch on the difference between what source of income discrimination is versus having a legitimate reason to reject or deny an offer or an applicant. So to give you a little bit of background, there was a recent case law in DC, which is DC versus voucher discrimination. So in December 2022, the District of Columbia won a historic settlement against voucher discrimination. So to give you some more background into that, DC received a $10 million settlement in its lawsuit against landlords who discriminated against renters with housing vouchers. This was a company, the landlord was a company that owned multiple properties, and this was the largest civil penalty for housing discrimination in U.S. history. And since we're in Maryland right next door, Maryland absolutely wants to make sure that this same thing does not occur here. So what the companies were cited for, they were cited for running ads with illegal discriminatory language, and they were found liable for actively engaging in discriminatory practices to keep voucher holders from applying for apartments. So they had also charged extra fees to applicants who were voucher recipients as well. So that in conjunction with advertising, charging extra fees, all of that culminated to source of income discrimination. Next slide, Taylor. So what source of income means, so we can avoid this type of outcome. So it means any lawful source of income paid directly or indirectly to or on behalf of a renter or buyer of housing. This includes financing and loans, and some examples of that are lawful professions, jobs, government or private assistance. It includes housing assistance, certificates, and vouchers. Sometimes people may think that this only applies to tenant vouchers, but it's applying to your source of income, which can mean VA loans, FHA loans, and so on and so forth. Keep going. And also to touch on that too, as Kathleen mentioned earlier, if there's a criminal component to the source of the income, then this is absolutely not covering that. That's not a protected group. That's not a protected class of money. So if it's a criminal association attached to it, you can absolutely reject those type of offers. So what the statute says, what's the source of income discrimination? Maryland says that except as provided in sections 20-703 and 20-704 of this subtitle, which we'll get into, a person may not refuse to sell or rent after the making of a bona fide offer, refuse to negotiate for the sale or rental of, or otherwise make unavailable or deny a dwelling to any person because of their source of income. Second, they can't discriminate against any person in the terms, conditions, or privileges of the sale or rental of a dwelling, or in the provision of services or facilities in connection with the sale or rental of a dwelling because of their source of income. The third point, in which that lawsuit in DC touched on, Maryland says you cannot make, print, or publish, or cause to be made, printed, or published any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on person's source of income, or an intention to make any preference, limitation, or discrimination. And then the fourth one, a person may not represent to any person because of their source of income that any dwelling is not available for inspection, sale, or rental when the dwelling is actually available. And then last, they cannot for profit induce or attempt to induce any person to sell or rent any dwelling by representations regarding the entry or prospective entry into the neighborhood of a person of a particular source of income. To summarize that a little bit, if you're at any point being the barrier to someone's entry into negotiations, you may be doing something that is in violation or towing the line here. If you're the barrier advertising, we only accept cash vouchers, or excuse me, we only accept cash offers, or no housing vouchers are allowed to apply. Those type of things are broad ranges of discrimination. And that's exactly what the discrimination, that is exactly what Maryland is trying to protect this class from, because if one realtor is saying, no, we don't accept this, another is saying, no, we don't accept this, and there's a chain event, there's a creation of a disparity of discrimination impact. So this is why the source of income had to be a protected class. Next slide. So exemptions from the source of income, so we can know the difference between when it applies and when there's a valid or legitimate reason versus when there's discriminatory reasons. So the exemption from this bill includes owners of property who do not use a real estate agent or other person in the business of selling or renting property. So if it's a for sale by owner, depending on the type of unit, they may be exempt. So owners will be determined to be in the business of selling or renting property if within the last 12 months, the owner participated as a principal in 3 or more sale or rental transactions. So as stated in Maryland Code, State Government Section 20-704, where the exemptions are, it says the statute that lists the acts that are not prohibited. These are non-discriminatory acts. Next slide, we'll get into what this means. So what is non-discriminatory? So the laws addressing source of income discrimination in Maryland are as follows. So this definition, source of income means any lawful source of money paid directly or indirectly to or on behalf of a renter or buyer of housing. Source of income includes income from a lawful profession, occupation, or job, any government or private assistance, a grant, a loan, or rental assistance program, including low-income housing assistance, certificates, and vouchers issued under the U.S. Housing Act of 1937. This also includes a gift, an inheritance, a pension, an annuity, alimony, child support, or any other consideration or benefit, or the sale or pledge of property or an interest in property. So really all-encompassing where the funds coming from. So those are all defined as source of income in that statute. So the prohibitions in the subtitle against discrimination based on source of income do not prohibit a person from determining the ability of a potential buyer or renter to pay a purchase price or pay rent by verifying in a commercially reasonable and non-discriminatory manner the source and amount of income or credit worthiness of the potential buyer or renter. Second, it does not mean it does not prevent a person from refusing to consider income derived from any criminal activity. Or 3, it does not prohibit a person from determining, in accordance with applicable federal and state laws, the ability of a potential buyer to repay a mortgage loan. What that's saying specifically is that there is a law saying you cannot discriminate, but the law is not saying that you must accept. So that's saying you have to have proper criteria, you have to have proper requirements that are in place in order to reject without a discriminatory practice in place. Next slide. So some type of, so an example of that. So landlord and tenant transactions, for example. So with the housing voucher, there's a question. Does this mean that every voucher tenant must be accepted? The answer is it depends. The factors to consider whether an owner must accept a voucher tenant include, can the tenant afford the advertised rent? Will their income and voucher cover the entire rental payment? If not, then they may be rejected or denied. Is the tenant's creditworthiness sufficient as determined by commercially reasonable and non-discriminatory methods? So if you have a requirement for a credit score and someone with a housing voucher applies and they don't meet that credit score, that's a requirement that they do not meet, and that is grounds to, it is okay to reject. Yeah, thank you. And other questions as well. Is the owner deemed to be in the business of selling and renting property? So this is for owner side, listing side. So is the owner deemed to be in the business of selling and renting property, which means 3 or more transactions in the last 12 months? If no, the owner may be exempt and they may not be held accountable for source of income discrimination. Is the owner working with someone in the business, i.e. a property manager? If not, the owner may be exempt. Does the owner live in the property which is being rented, and does the property have 5 or fewer units? If yes, then the owner may be exempt. So is the owner exempt from this Maryland law? Those are the 3 questions that you want to ask your client. So if any of these factors apply, then your client may be exempt from the source of income statute. Moving forward. So background discussions on how to calculate the proper housing voucher. This question has come up a few times of how do I calculate to know whether or not a tenant does actually meet the criteria? And that's where you want to make sure that you're calculating correctly and you're not blindly applying a rule that's not aware of how you're supposed to calculate for people with tenant vouchers. So some background discussion in this. In the past, some public housing authorities like Baltimore County have advised housing providers that they could treat housing assistance and vouchers as if it is income when calculating the applicant's total income. So for example, if the voucher is $1,000 and the total rent for the apartment home is $1,500, then the rental housing provider would use the $1,000 times 12 months as $12,000 towards the income of the applicant. This is then used to determine if the applicant meets the minimum income requirement. So hypothetically, between 54,000 to 60,000 minimum income, depending on the housing provider's minimum income requirements. So that's how you would do your calculations. Another way to calculate, the Maryland Commission on Civil Rights, MCCR, which supports the Public Housing Authority, advises that housing providers should apply any income requirements only to the voucher holder's portion of the rent. So using the example above, if a unit rents for $1,500, the applicant has a $1,000 voucher. The voucher holder will be responsible for only $500 of that monthly rent. Therefore, the applicant would only be income qualified on the $500 of monthly rent or $6,000 of annual rent. So you're judging them for just their portion of what they're expected to cover for that rent. So hypothetically, between 18,000 and 24,000 minimum income, depending on the housing provider's minimum income requirements. And the discrepancy in guidance has created confusion among members as to how housing assistance and vouchers should be calculated with respect to income. So Maryland wants to make sure that you're calculating correctly, that you're not, like I said, blindly applying that requirement when there's a stipulation there that how you're supposed to be calculating that housing voucher holder's income. So if you're using the incorrect application of it, then there's a chance that you could be, actively practicing source of income discrimination unknowingly just from using the wrong calculations. So MCCR is the administrative agency charged with investigating and issuing decisions regarding discrimination complaints. Failure to use MCCR's methodology, could result in a claim or potential finding of discrimination based on income. Therefore, it is advised that property owners follow the guidance issued by the MCCR in calculating the voucher holder's portion of rent. So this calculation is widely accepted across Maryland of how you're supposed to calculate. And MCCR, for those who don't know, that's a resource site, Maryland Commission on Civil Rights. If there's at any point you feel as though your client or yourself has experienced any type of discrimination, source of income discrimination, you can reach out to this agency and they'll look into it, they'll investigate, and I believe they may have pro bono attorneys as well who are willing to take on the case if there is a lawsuit mandated situation. Next slide.
That might be it.
Okay, that was me for source of income discrimination. Thanks, Haley.
All right, great. Thank you, Diamond. So I just checked the time. We're running a little low, so I will try to be as concise and quick as possible. So changes to our escrow agreements. The change we made in October of this year was a change to the distribution of deposit paragraph in response to Senate Bill 651, a new law that was passed this year. So this new release of deposit procedure, which I'll explain in detail, it's only going to apply when the buyer terminates the transaction pursuant to a contingency, and the word contingency is defined under the statute. So that old release of deposit procedure that brokers and title companies have been using for the last, however many years, that's still in effect, and that's going to be used when the buyer terminates for a reason other than a contingency, again, as defined in the statute, or the seller terminates. You're going to want to use that old release of deposit procedure. So I am going to pull up that change. Actually, first, let's see. All right. Can you see that, Diamond?
Yes.
Okay, great. So this is our escrow agreement. The distribution of deposit paragraph here. So this is the old language, that old release of deposit procedure. And we just added in here, if the buyer is not terminating pursuant to a contingency, or if the seller terminates, you're going to use this. But if that buyer does terminate pursuant to a contingency, as defined under the statute, you're going to use the new release of deposit procedure. So what is a contingency under this new statute? I will pull up that list here. So this is direct language from the statute, and this is the list of contingencies. It's an exhaustive list. So if a contingency falls outside of whatever's on this list, it's not going to be considered a contingency for the purpose of determining which release of deposit procedure you're going to use. So it's, as you can see, 15 listed contingencies here. I'm not going to read through all of them, but one I do want to point out is it is considered a contingency if it is relates to a third-party approval not related to financing. In other words, financing is not considered a contingency under this new release of deposit procedure law. So if buyer terminates the contract due to unable to get financing, that's not going to be considered a contingency under this new law, and you're going to use the old release of deposit procedure. So what exactly is this new release of deposit procedure? So let's say the buyer terminates pursuant to their HOA review period. So they terminate during their review period as they have the right to, and then that buyer is going to make a request for the return of the deposit. So they're going to send that request to the seller and whoever's holding the deposit, whether it's a broker, title company, whoever that escrow agent is. After once that request is received, the clock starts. So the seller has a 10-day window after receiving that request. If they want to fight the release of that deposit, they must provide whoever's holding that deposit with a notarized written request for mediation. So on the buyer, I make my request. Seller has a 10-day window to send that notarized request for mediation to the escrow agent if they want to fight the release of the deposit. If that escrow agent does receive that written request, notarized written request for mediation, they're going to hold that deposit until either, where are we here? A mediation agreement authorizes the distribution of the deposit. So buyer and seller come to some agreement, or that escrow agent can file an interpleader action in the district court. If that escrow agent does not receive that request for that written notarized request for mediation within the 10-day window, then they shall distribute that deposit back to the buyer within 30 days after they received that initial request. So that's the new release of deposit procedure. Really, the questions we get are what is considered a contingency, and it's in that exhaustive 15 listed out contingencies in the statute.
Taylor, I would say the other question that we get is the other question that I've received is a written request for mediation that has to be notarized. An email saying I'm going to file mediation is not the same as filing a request for mediation. So it has to be an actual request for mediation that's been filed with the mediation company, and it has to be notarized. An email or a phone call saying I'm going to file, that's not sufficient under the statute.
Right. Okay. Oh, I got ahead of myself a little bit. This is just explains what the process is, which I just explained. And so does this. Okay, now for advertising, Kathleen.
Yeah, I'll do this quickly as well. This advertising checklist that is up here, it's just we're showing this visual just because some of you may have seen this before. Actually, hopefully all of you have seen this before. The Real Estate Commission is in the process of updating this because there have been a couple changes recently, right? The changes, there was, let me see, I think three changes. One specifically with team advertising. The way the law was written before, it said that the name of your team had to be directly connected to the name of your brokerage, right? And, you know, for a couple of years, people would be like, well, what the heck does directly connected to mean? Which we would say, well, that's a good question. They haven't given any guidance. Well, in 2022, we did get some very clear guidance on what directly connected to means. And what that is, your team name has to be directly connected to the name of your brokerage. And it's really specific. They say sometimes be careful what you ask for, right? So we have very specific, very narrow guidance. The team name has to be directly connected to the name of the brokerage using 4 words. We're calling them the magic words, right? Of, from, with, or at. The D'Artes team of the Diamond Real Estate Brokerage, right? Of, from, with, or at, no symbols, no ampersand, no other words. That's really it. Of, from, with, or at. That's what directly connected means. So that's kind of the easy part. The other change involves electronic advertising. all of the required information, which is basically on this checklist. You have to include your name. You're going to include your phone number. You have to include your company phone number, a team name if you're part of a team, of, from, with, or at, your brokerage name, right? All of that's the required information. If you're using electronic advertising, which most of us are now, all of that required information has to appear on the top 25% of the main page of your electronic advertisement, right? So if you have a personal web page and you want to, you have to include all the required information there for the advertising to be compliant. All of the required information would have to be on the top 25% of the main page of your personal website. Some of you guys, if you're with larger brokerages, your company may provide a template. Some of those, they focus on the agent up top and they might have the brokerage information down at the bottom. Just heads up, that is not compliant with Maryland law. All of the information has to be at the top 25%. Think about it, the Real Estate Commission, they're consumer protection oriented. They want someone who pulls up your website to be able to look at it immediately, know that you're part of a team, get your phone number, know which brokerage you're affiliated with. They don't want the person to have to go scrolling through the page to try and figure out which company you're affiliated with. So that's relatively straightforward. The only exception to that electronic advertising, this exception is called the one-click rule, right? The exception applies only if the app or platform that you're using to advertise, if it has a character limit of 280 characters or less, right? And I think the easiest example to think of is Twitter. I guess we're supposed to call it X now. But if you want to put tweet something about your listing, there is a character limit on Twitter of 280 characters. I think there may be some exceptions, but let's just assume for purposes of this conversation that it's 280 characters or fewer, right? So I want to put it, to post a tweet about my new listing. I'm not going to be able to fit my name, my team name, of, from, with, at, brokerage name, my phone number, company phone number, and then talk about the property, right? There just won't be enough room there. So the one-click rule would allow me, I could put a tweet up about my property. I could say, hey, check out my new listing. I could have my name and my phone number, but I have to include a hyperlink, right? And the hyperlink is so the user, the consumer, can click on that hyperlink, and with one click, they'll end up on my electronic page, my business page, or on a page that does include all of the required information in the top 25%, right? So that's the loophole, and it's only for platforms or app with a character limit of 280 or fewer, and the exception requires that your advertiser, you as placing the ad, you have to include a hyperlink. When the consumer clicks on it, voila, your page pops up and they see all of the required information on the top 25%. So that's the changes that took place last year with respect to advertising. And I think that's probably the only other thing I will say. The Real Estate Commission, if you guys have been ignoring the advertising rules and thinking I'm not going to get caught, or the Real Estate Commission doesn't enforce those pesky rules, well, you are wrong. The Real Estate Commission does enforce those pesky rules, and they've kind of had an uptick in that recently. So pay attention to that. We talk about this in our ethics class, but there are some cases where salespersons have been disciplined recently for not complying with the advertising requirements. A fine was imposed on the 2 salespersons. They had to pay a fine of $2,500, and the brokers had to pay a fine also. The broker's violation was not reasonably and adequately supervising their agents by not reviewing their ads. So just a heads up, pay attention. The rules have changed, and the Real Estate Commission has kind of stepped up its enforcement action with respect to advertising. So it's the end of the year. Review your marketing materials, review your ads, talk to your broker or office manager if you have any questions, but just be aware that the Real Estate Commission has kind of tightened up on that. These other bullet points up here are things, again, that have not changed. Your advertising has to present a true and accurate picture. That's been the case for years. Don't violate fair housing advertising requirements. Again, there's good information on NAR's website on that. And be mindful of what you post on social media. Good guidance in general. That kind of is something that we touch on in the Code of Ethics as well. Depending on what you post on social media, if you post something that is sort of a fair housing violation, that's hate speech or harassing speech, epithets or slurs against someone in a protected class, it's possible that you could be subject to discipline under NAR's Code of Ethics. So just be mindful of what you post on social media as well. post pictures of your beautiful cats, your dogs, and be careful what you're posting on social media. I think that's all we were going to cover. We have some time for some Q&A, I think. You want to go back and
Sure.
read
Yeah,
some questions?
I was trying to answer through the chat, but there are a few more I can't get to. So yeah, we can answer them live. I just received, I was just on, it says, I'm not surprised. I constantly tell agents not to even say the word Section 8. The landlord will consider all applications, regardless of where the lawful source of fund comes from. I'll also say submit a lease application so the landlord can consider the entire picture. That's a great way to protect your clients. I think that's a way to make sure that the landlord is considering all applications, because yes, they are depending on, whether or not they're exempt or not, but they are required to consider all applicants at face value. That wasn't a question, but thank you, John.
Yeah, I had responded to another. He said, it was agents saying that does the landlord accept vouchers or list? And I said you might be surprised how many listing agents respond no, the landlord does not accept vouchers. Obviously, that's what we just talked about. That is not permissible here in Maryland. That is discrimination based on source of income. Another one, this one we could kind of all maybe talk about this. Is there a way to protect the U.S. FHA, VA, USDA buyers from spending money on appraisals and inspections on homes that will not qualify for financing because of conditions without appearing to discriminate? Right. So I think what everybody probably understands that question. I think if you are, you're the listing agent listing a property and there may be some issues with the property condition, and or think that this property will not satisfy FHA's requirements or VA's, minimum property requirements. Hey, isn't that, this poor buyer is going to have to get an appraisal and go out of pocket and spend some money, and the property is not going to satisfy the lender requirements anyway. Can't we just say no VA or no FHA? And the answer, of course, is no. You can't just say no VA, no FHA. That is discrimination based on source of income here in Maryland. Very clear, no question about that. The Real Estate Commission has issued guidance on that. There's FAQs that are absolutely clear on that. I think the real question is, though, how do you communicate that information to a potential buyer? And again, from the buyer's agent side, you don't want your buyer to be putting in a bunch of offers on property if they're not going to qualify for financing or if the lender's not going to make any repairs. I would just say two things to be cautious about. One, remember, like FHA, even if there are issues with the property condition, FHA has a variety of loan products. They have 203K rehab loans, right? So even if there are significant issues with the property or issues that need to be repaired, it's possible that the buyer could get a 203K rehab loan and still purchase that property using FHA financing. So even if you're thinking that it won't qualify for FHA, it's possible that it might. And another one, condos, FHA, the condos have to be certified on whatever, it's Christmas time, the naughty and nice list. They have to be on the nice list for FHA, but that is even also possible if they're not on the approved list. It is still possible to get a spot approval for one particular unit. So I would just say be cautious there. Something that you think might not be eligible, it still might. I think the best practice, if possible, get the seller to do, if the seller does a disclosure, have them answer accurately and, disclose the age of the roof or whatever issues might be there. The other thing I would say on the buyer's agent side, be aware of any issues that might pose a problem or make it more difficult for your buyer's loan to be approved. So the buyer's agent should have some awareness and share that information with the buyer as well. Is there another question, Diamond?
Yeah, you just said what I was going to say too about the buyer. If the buyer's agent is aware, they can make that determination with their client, but it's not a fact that they will not be approved. You may think they may not, but the savviest of realtors may be able to find a way to help their client, or they can take that decision and say, this may be a hurdle we'll have to face, but you have to allow them that grace to take over. And then the other question regarding source of income I saw is, how can a loan, conventional FHA, VA, be considered income if it's not taxable? It's not taxable income or non-taxable income because it's not income. I'm just confused on how we're considering.
Oh, sorry. It's the statute. That's what it says, that in the law.
Right.
It specifically says loan. And again, you guys, just one caution. I say this when I teach class. don't go to Facebook Esquire for your information, because source of income in Maryland, the loan type is considered source of income. In another state, it may not be considered source of income. It depends on how that state defines source of income. So don't use Facebook Esquire for your legal advice and your legal answers. Call Taylor and Diamond and me. That's call it Legal Hotline. That's what we're there for. But the Maryland statute does specifically include the loan, the type of financing being used by the buyer. So in Maryland, that is discriminatory. It may not be somewhere else.
We didn't write the law. We didn't
Yeah,
write.
we don't make the law.
I think I saw.
Let's see, where can I get a list of approved contingencies for the new escrow agreement? It's in the statute that's referenced in our contract of sale and the escrow agreement. And that statute's pretty readily available online. Actually, Kathleen, I know you just wrote an article for our Maryland Realtors magazine. The contingencies are listed in there in Kathleen's article as well. So yeah, that's where I would look first.
There was another thing Taylor said, if the buyer wants to terminate since the seller has offered in lieu of repairs, does the new EMD law apply?
Say that again, I'm sorry.
It says if the buyer wants to terminate since the seller has ordered in lieu of repairs, does the new EMD has offered, excuse me, that's okay. So if the buyer wants to terminate since the seller has offered in lieu of repairs, does the new EMD law apply?
Yes. That
Yes.
The property inspection was one of the contingencies that was listed in the statute. Yeah. Hey, I have an easy one. I just saw, where do I go to get a nickname added to my real estate card? Go to the Real Estate Commission website. You guys, if you have, I'm Kathleen D'Artez. If I wanted to be Kathy, I can't just do that. I have to register my nickname with the Real Estate Commission, go to their website. I believe the fee is $25. So if you have a nickname that you use, you pay the $25 to the Real Estate Commission, complete that paperwork, and then you could use your nickname, market yourself using your nickname, advertise using the nickname, but you are supposed to pay the $25 to the Real Estate Commission first, or you're supposed to use your legal name. So that was a good question. Thank you.
We're at 2:01.
All right. I think we are good. What happens if the financing falls through? I'm just going to throw that. Taylor had mentioned that already. If the financing falls through, that does not trigger the expedited release of deposit process. So it's the same process that you guys have been using forever. There would have to be a mutual release of deposit signed by buyer and seller, or the parties would have to go to mediation. All right, I think that's it. We want to respect everybody's time. For those who joined late, this session is being recorded. We do share our recordings on our YouTube channel. You might have to give us a little grace on this one. We are closed next week for the holidays, so happy holidays all. But we'll get it up there as soon as we can, and feel free to look at that, share it with your colleagues. I think
I was going to say, I saw a question just come in. If you want to put that into the legal hotline, we can answer there as well.
Perfect.
Thank you, everyone. And yes, as Kathleen said, this will be sent out to all registrants via email. I'm going to hope for Friday. So tomorrow you should probably see an email from me at webinars@mdrealtor.org. And then we will get it up on our YouTube page so that you guys can have that before the new year. But thank you all. We will have upcoming webinars starting back up in January, so stay tuned. They will be posted on our social and sent out in our hot sheet. So keep an eye out for our upcoming webinars.
Oh, we have one last question. Greg Fisk said, "Let's go Ravens." Let's go
I
Ravens.
don't know if that's a question, but we'll take it.
All right, we'll close on that, and we'll have our Chicago colleague be quiet. All right, thanks everyone.
Happy holidays.
Thank you.